he's set to go on trial this summer for the quadruple murder of the 4 University of Idaho students. And his lawyers are now claiming that prosecutors in their case missed a critical deadline to hand over a batch of discovery evidence that they plan to use against Kohberger in his murder case, right? If you remember back in Lori Vallow's case, the state handed over evidence 1 day late. 1 day late. They missed a deadline. And the judge was having none of it. He was not playing. He took death penalty off the table for Lori Vallow. Not for Chad Daybell, but missing a discovery deadline. They took death penalty off the table for Lori. So it looks like Kohberger wants to do the same thing, which is why I need to talk to Alexandra Kazarian, who's a senior trial attorney with the firm Garagos and Garagos. I don't know. There's a lot of differences between these two cases, but I'm going to leave it to you. You're the expert, Alexandra. Tell me what you think.
Yeah, there's huge differences. One difference that's not supposed to matter, but it does, come on, let's be real, is the fact that she's representing herself. No attorney would ever recommend that a defendant in any case represent themselves, much less a case where you're facing the death penalty. But when you do, and when you are really showing that you're making an effort, you're not just creating a circus, you're actually working on the cases, you're trying to learn, you're trying to be respectful, I think it does make a difference with the judge. That being said, I think the biggest difference is that she has not waived her constitutional right to a speedy trial. That's the biggest difference, because even though there's only 1 day in the Lori Vallow case, that 1 day is huge because she has not agreed to continue it at all. And when you're in that initial time frame, timing matters. And the evidence that she was asking for was in control of the prosecution before they even, some of it before they even brought the charges, but it's always been in their control and in their possession. So there is no excuse for them handing it over late. So when you haven't waived your constitutional right to a speedy trial, that's the biggest difference.
Yeah. Oftentimes people will do that strategically because they don't think that the prosecution has all their ducks in a row. So it's like, bring it on, baby. I'm ready to fight this now because you're not going to, you're going to leave some reasonable doubt for the jury. I doubt that that's what Lori Vallow's strategy is. It's been quite a while since Charles Vallow died, and they've been investigating it for a very, very long time. Plus, they have that itty-bitty inconvenient detail that she's a triple murderer. You can bring that in. By the way, you can bring that in. That is not one of those, bad facts that you're not allowed to bring in, correct? Any prosecutor in Arizona is allowed to say, and by the way, she's already a triple murderer of her own kids.
Oh, absolutely. Anything she says, they're going to say, do you believe her? She's a murderer, not once, not twice, but 3 times. So yes, absolutely. Anything that comes out of her mouth, whether now she's representing herself, whether it's as an attorney or whether it's as a defendant giving testimony about the case herself, every single thing that comes out of her mouth is now under the scrutiny of impeachment because of the prior convictions. And I mean, that's probably the biggest reason that you don't represent yourself once you've already been convicted of murder, but there's just so many reasons why it's a bad idea, appellate issues included.
Yeah, because you got to be on your feet. I've been doing this for such a long time, and I miss hearsay all the time. And I always, I'm always amazed when those very quick-thinking lawyers can hear it and catch it, all the different kinds of exceptions to hearsay. There should be an entire law degree on just hearsay. It is not easy. It's not like the movies. You got to be on, on the ball and on your game. And she wasn't even competent to stand trial. So there's that. Question for you about the discovery, because I was so mad when I saw that happen in Idaho. And it sounded like it was almost like a communication gap. The discovery came on the day of the deadline, if I remember correctly. And the wording was before this day. And that's why it ended up being late. So it was like such a minuscule difference that cost the people of Idaho the opportunity to impose the death penalty in the sentencing phase. In this case, it's not the same. It's not really a deadline. It's my understanding that Kohberger's lawyers are complaining, 8 months out, that the discovery they got was too broad, not necessarily that a deadline passed. Is that correct?
Yeah, I believe so. They're saying that it's that the prosecution is essentially trying to bury the defense and not give them the opportunity to really figure out what's going on, because they're taking too much time to try to go through it and not giving them the specific examples. And yeah, that's not as actionable as actually missing a deadline.
Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.